Well, in our coverage, ongoing coverage of the Murdaugh murders trial, the big question now, will Alex Murdaugh take the stand? Our expert analysis is back today with trial attorney Carl B. Grant. Carl, I want to start with an exchange that attorneys had in the courtroom today. The defense essentially trying to put some limits on what an Alex Murdaugh cross-examination might involve. Let's take a listen to that and we'll get into it on the other side.
And here he's charged with murder. He's not charged with financial crimes. He's charged with murder. And we're asking the court to limit, the waiver of his Fifth Amendment privilege to the murder charges.
Yes, sir.
Again, moving back to 607, of course, the credibility of the witness may be attacked by any party. 608B allows examination, a cross-examination of a witness concerning their aspects of truthfulness and untruthfulness, which this clearly goes to, as well as 608C, which talks about bias, prejudice, and any motive to misrepresent. And again, we're not just talking about purely dishonesty and credibility, which I think is alone more than enough. We're also talking about examination on issues that are specifically relevant to this particular case based on the 404 ruling.
Exchange went back and forth quite a bit, but basically it sounds like the defense is saying we want to put him on the stand, we just want to pick what we talk about. Is that argument going to fly?
No.
And the judge made it clear today.
Yeah, I don't think it will. The defense will not get an opportunity to cherry pick the questions and determine which ones they want to answer and those that they don't. Once he gets on the witness stand, as I've said before, if he takes one bite, he's got to eat the whole apple.
And that's what the judge said, is basically he'd have to get on the stand first, and then I will take those things one by one to decide what will happen. So my question about Alex Murdaugh testifying in his own defense, is that possibly a defense tactic to put this subliminal thought in the jurors' minds of, oh, well, if you'd be willing to put him on the stand to testify for himself, well, then maybe he is innocent, but then have no intention of actually putting him on?
Right, you mean to communicate that through the media
Yes,
some kind of
yes,
way?
because we're all talking
the jury was out
about
of the
it.
courtroom today for that, so I'm not sure if they know that he might testify,
but
they're
know.
wondering.
Right,
they're wondering.
they know.
Sure, and that could be a strategy. However, I can tell you this, it would be my professional advice if I was his attorney, again, since his exculpatory statement has been out there and he's on video saying I didn't do it and he's actually crying saying so, I would not allow him to get on the stand. At least I can't stop him because he's the client. However, I would protect myself as his attorney because the client, if he's convicted, at that point can challenge you and go after you and argue ineffective assistance of counsel. I would have him sign what is called a confirmation of advice and decision. Sign here saying I've advised you of the risk that you're taking. Now you made the decision and you understand the consequences to use that later in case he wants to challenge me.
Interesting. Would there be a purpose, though, for putting him on?
Well, the only purpose that I could see logically is who is going to explain this issue, whether he was at the dog kennel or not. If there's anybody else on the planet who can talk about that.
Yeah, no one else can really address that.
Right, if he's anybody else, I would certainly not put him on, but that's the only benefit. But here's the thing, you really must do what is called a risk-benefit analysis.
Yes.
On that one point compared to all the other things that he could be cross-examined on, all the various admissions of lying, one by one. I mean, the domino effect. One after another. I don't think I'd ask him to get on the witness stand or agree to him to do so.
Well, in making that decision to put him on almost as an admission of we don't think we are winning this case. But let's talk about the jurors. We're down to 2 alternates, Carl. How concerned? I mean, obviously, if we're talking about the possibility of putting him on the stand, we're getting closer to this being sent to the jury, but we still got to get through the prosecution's rebuttal. So the fact that we're down to 2 alternates, how concerning is that?
Not only is it concerning about 2 alternates at this point, but not only you got to get through the trial, you get through the closing argument, but they have to get through deliberation.
Yes.
I tried a death penalty case one time, and one of the jurors who was actually deliberating took sick. And when you talk about only 2 people, that puts this thing in a very tight situation, whereas if you get less than 2, and now you're dealing with 11, less than 12, of course, the judge would have to declare a mistrial, because if I'm the defense counsel, I'm not going to agree to try this case with 11 people.
One thing that we really saw in today's testimony was the defense really going up against SLED and the investigators from the Sheriff's Department and others for not having booties on their shoes, not having a platform that they could walk across to not contaminate anything. We have to remind our viewers that even if somebody really thinks in a case someone did it, it just creates, if there's just a little doubt, and it gets the jury to say, well, it was, we just can't, because there's that doubt. We can't convict.
Well, the question becomes, Donnie, what is the doubt going to be about? Is the doubt about whether or not you had a stellar investigation and the scene was not contaminated? Or is the doubt really about whether you committed the crime?
And so the prosecution would have to say, okay, so maybe they didn't, dot every I and cross every T, but the point is who did it, and they would have to hone in on that.
Sometimes as a trial lawyer, you have to admit the deficiencies that your case has in order to maintain integrity and credibility with the jury.
Let's talk about Jim Griffin, because he took some heat from Judge Newman about a tweet that he posted criticizing witness testimony. What's your assessment of how the judge responded and what that response could have been?
Well, the judge responded well. The judge, again, is just a very nice guy. But now he could have done a lot more if he wanted to. He could have issued a gag order on everybody, saying nobody can communicate or talk about it on social media or have any type of social postings. He could have done that. He could have actually said, I'm going to issue you a fine, contempt of court. Now, that's a very serious thing. I've been asked whether or not the judge could remove him from the defense. The judge would not do that because of many different reasons. Number one, the Sixth Amendment. He's entitled to have his counsel. And if the judge did that, then the judge would obviously impede upon his right to the effective assistance of counsel and would set this thing up absolutely for an appeal, okay, to have them tried all over again, because naturally this man has been in the case from day one, and he's essential to the defense. So removing him from part of the defense team would certainly not be a decision that would be wise for the judge to make.
Talking about Buster Murdaugh testifying yesterday, in a case like that, and we're not going to comment specifically on this one, but in generalities, when you have a family member, especially a child where one parent has been killed, the other parent's on trial, a lot of times people will say, they don't want to lose that other parent, and so they choose to maybe not believe what they think is truth. Now, we're not making a comment on this one in particular, but do you often see that? Because there are a lot of people thinking, why would Buster not be mad at his dad? Does he truly believe his dad is innocent?
This young man is he has
quite a
some
conundrum.
serious conflicting emotions going on here.
Sure.
Yeah.
He's got to think about he's a victim on one hand because mom and brother have been killed. That's his immediate family. Then on the other hand, dad is being tried for murder, so I feel sorry for him. I mean, I really do.
Sure.
So I don't know how he's handling emotions, but he's in a very, very difficult situation. And I really feel sorry for him.
Carl, when we think about looking ahead to, well, first of all, the cross-examination, the defense has tried to call, as Dondi mentioned, call the investigation itself into question. But the defense has pushed back hard, challenging the expert credentials of these witnesses. I mean, one witness got on the stand and said repeatedly, well, I'm not a pathologist, I'm not a weapons expert. One witness for the defense today, said, I make mistakes, and Meadors zoned in on that. How effective has the cross-examination been in your mind?
I think they've been great, actually, for both sides, Judy. Again, when it comes to experts, it really depends upon their credentials, their experience, and I always call it the battle of the experts. You may have expert A for the prosecution, then you have expert Z for the defense. Sometimes they cancel each other out. Now the jury has to decide, well, who has the most experience, who came across as the best witness, and then they determine who are they going to believe based on all the other evidence, and based upon their demeanor. That's how jurors evaluate which expert they're going to believe more so than the other.
So we are wrapping up our interview with you right now. The defense might wrap up by the end of the week, but likely we're going into early next week with the closing arguments, right?
I would imagine so. Once the defense finished presenting its case, the prosecution had the opportunity to put on what is called a reply case. Now, the reply case is replying to obviously what the defense has submitted. That normally does not take long. And trust me, in this case, the jury does not want to hear the same thing over and over again.
Sure.
We've had too much of that going on already.
Well, and we get into that whole issue of keeping those jurors healthy, to keep those 12 jurors
Get it
on the
done.
bench to deliberate.
Yeah.
All right, final word. What's your call? Will Alex Murdaugh take the stand or no?
I don't think he will.
Okay.
I don't think he will. But a lot of times, hubris gets in the way.
Well, we've seen it happen before,
yes,
haven't we?
Sometimes a person wants to get on the stand because they think they can out-talk the situation and persuade their way to victory. And oftentimes that turns out to be the defendant's downfall.
We
All
will
right.
find out. We're watching again tomorrow. Attorney Carl B. Grant, thank you so much. As always,
Excellent.
join us again tomorrow for more analysis.